Y'all come on up in here. Y'all know what time it is tonight, man. We got some great information to drop to you guys tonight. So I hope you guys are ready to receive, because we got a lot of great information for you guys, right? Let's do it. You already know the routine. When you first come up in here, hit that share button. Hit the share button. Like and subscribe. As you know, we are on YouTube, In God We Trust Academy. We're also on Facebook, In God We Trust Academy. Twitch, In God We Trust Academy. Yeah, lock in with us. As well as on TikTok, In God We Trust. MNRP 2023 is in the house tonight. 619-2020. Yeah. I hope y'all really ready, man, for the night. Are y'all ready for the night, man? If you are, drop some ones with us, man. Let us know that you're with us, man. And like I say, I'm really excited about this. So go ahead and hit the share button. We're going to do false imprisonment tonight. So that's what we're going to be speaking on. So let's go.
You break the code, you deport now. We play the game like a sport now. Endorsement straight from the hood now. Man, on my way, then we good now. Don't approach me unless you more now.
Yeah, y'all with us tonight. Drop some ones.
Pick your head up, don't hit head down. The struggle will sun up the sun down. I found my peace and we here now. Cold or honor up in here now. So lay down the law, keep it real now. They lower your oil, it's man down. I got a few killers that shooting around. You know we keep peace, ain't no backing down. He said for my family, now he asking for treaties. Just watch out them niggas who acting so greedy. Them be the people who heart is so evil.
Y'all know what time it is, man. Get in here. It is time. It is time. It is time. It is time. I hope y'all is ready to receive, man. Ready to receive. Ready to receive. Are y'all ready to receive tonight? If you are, drop some ones and hit the share button, man. As again, we're gonna make sure we take care of y'all, man. So let's go. Let's go, let's go, let's go. What's good with y'all? How y'all doing, man? How y'all doing tonight? Everybody good up in here tonight? I need to see some ones dropping. I need to know y'all with us tonight. There we go. We're getting a few of them up in here, man. Oneness always, right? That's what it takes. 1 + 1 = 1. Yes, because the common denominator of everything is 1. That is a fact, right? Man, so I'm glad that you guys are doing great tonight. That's beautiful. All right, so tonight, guys, we're going to be talking about false imprisonment. So we would like to welcome you guys to In God We Trust Academy on our podcast here. And always such a beautiful thing to be here and to deliver this to you guys and just being present with you here and this God-given beautiful day, being able to serve. In order to serve God, man, you got to serve people. And that's a fact. I don't think you guys understand that. We say we know where God is and know that ye are God. So just pay attention. So just serve. Serve the people. Serve your people, right? That's what it's always about. Always about, right? So what we'll like to do first, man, is let you guys know about the work sessions. As you see the flyers pop up on here, In God We Trust Academy work session season 5 is what we are in. So tomorrow at 11 a.m. Central Time, we will be having class. Okay, so these are just podcasting and stuff like that. So the class is being podcasted now too, but I just letting you know that that's why you won't hear people in here asking questions or giving testimonies at this time. That is on Mondays and Wednesdays. So you guys can lock in with us on that. Also, we have the private administration coming up. The conference is December the 7th. Okay, December the 7th, 10 a.m. to 4 p.m. In person is $250. Live stream is $200. And we will be talking about private court settlement. How to, different financial strategies and also lawful money protection, right? So make sure you guys know that that's going to be here in Huntsville, Alabama. So you guys are definitely welcome to come out and enjoy and have a great time with us. There's going to be a lot of information being given into this particular place, man. So, yeah, we're going to talk about your rights, lawful money, taxation. We're going to talk about it all. So this is a pretty much like an overall coverage of everything that we've done throughout this whole entire year. So if you've been with us this whole entire year, this is going to be an all like a super compact of all the info that we have done throughout all the conferences and everything like that. So it's going to be a beautiful time for that as well, just so you know that, right? And don't forget about the White Friday sale. I know it says 2025. We got an error there, so we'll correct that later. But it is this year. So on November the 29th, 2024, that is, we have a White Friday sale, 50% off. Okay, so I hope you guys do participate. You can go on my website and everything will be half off except for the upcoming class, private administration. Other than that, though, everything else is what you want it to be, right? So that is on your job to definitely take care of the duties that you want. So just know I'm giving you a great opportunity to, get the classes that you want, make the things happen that you want to make happen, right? Absolutely, absolutely. So with that being said, though, everybody's great. Great to see you guys. And always give thanks for your time because you could be doing anything else right now. You could be scrolling up and down on these social medias. I mean, it's so easy to get distracted. So I always appreciate everybody, my day ones, those who always lock in with me, those new members, etc., those who are watching and paying attention now. Just know that it is also coming for you as well. So we appreciate you if you do stay. And I'm pretty sure you will be back or whatever the case may be. I know people who got stuff going on. But again, without you guys, none of this is possible, right? None of this is possible. So I give thanks to that. I give thanks to that, right? For you guys. All right? I definitely give thanks for that. So what we need to do is, let's jump into it, man. Tonight we're going to talk about false imprisonment. So everything that you guys hear from this point on is for educational reasons and religious purposes only. Anybody seeking any form of legal advice, please do seek a legal advisor, as it is my religious duty to speak my religious truth and experiences with you guys here tonight. All right. So if you're ready, let's see if you guys are ready, man. I gotta know y'all ready. So let me know you're ready, man. Give some praises up, drop some ones, and let me know. Like, subscribe, and share. Let's go. Let me know you with us, man. Before we get started, let's go. Let me hear what you guys got to say out here tonight. Yeah. Where y'all from, man? Where everybody at? Because you know what time it is tonight. We're going to learn a lot tonight. All right. What's up, Brian Langford? Jordan Rivers just popped in. Maryland. Okay. Maryland in the house. Illinois. What's up? OKC. New York is with us tonight. Okay. Man, it's beautiful, man. I want to come do conference at these places, man. Let's make something happen, you know. Straight up. I like to travel. Cali. Oh, man. Cali was beautiful. Cali was lovely. I will say that. Appreciate that. Dallas. I definitely want to do one in Dallas. Haven't done Delaware. Yeah, I'm ready, man. Let's make some things happen. Yeah. All right, man, let's get you guys started on this right now tonight. So we're going to be talking about false imprisonment, right? And on false imprisonment, and what we're speaking on here in false imprisonment, all right, a treaty on false arrests and imprisonment. So we're going to be reading from this, guys, and this is something that you need to know, because I think a lot of people don't understand when it comes to warrants and stuff like that. So let's do some groundbreaking here. And I like to read this. I've read this numerous of times, but it's just always great to, you know, study and stay on it and, you know, never depart from this. Joshua 1:8. Somebody drop that in the chat for us tonight. Joshua 1:8. Drop it in the chat. It is always good for somebody to see. Remember, time plus consistency equals growth. All right, so let's grow tonight, right? Let's grow tonight. Virginia, what's up? Virginia in the house with us. That's what's up. New Jersey, okay. All right, so this is by Charles A. Wiseman right here, and you can read this. This is a very great thing to read. Very great understanding here. All right, so the definition of false imprisonment, guys. The definition of false imprisonment. Okay, you guys ought to see a little. Let's get this about right. Y'all ought to be able to see about right there. I think we ought to be good right there. Okay, so false imprisonment consists of any type of unlawful restraint. Any, guys, keyword, any, keyword, okay? Always know the keyword is any. Any type of unlawful restraint or interference with the personal liberty of an individual. Okay, it basically involves any unlawful violation of the liberty of another. So, the ancient English legal scholar Henry de Bracton tells us that false imprisonment is one of the oldest violations of rights known. Forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. So false imprisonment is classified as a tort. So it's a tort, guys, under the common law, and also as a crime, right? It has been labeled a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for a remedy. So depriving, woo, that is a big word. That's a heavy word, right? A heavy word. Depriving a person of their liberty is legally no different than depriving a person of their property. So again, now your liberty is looked at as property. So when we talk about property and knowing that your right and liberty is intangible, okay? So in speaking on as your liberty as a form of intangible property here. So a theft of liberty is a wrong by which remedy can be had, just as the case with the theft of property. So it's the same. It's considered theft. Interesting, right? False imprisonment is a great offense due to high regard the law has for liberty. So in Chitty's practice of law, it states the infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonment or malicious prosecution. Wow. So like unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. So actual seizure or the laying on of hands is not necessary to constitute an unlawful detention. So it doesn't have to be an actual seizure. It doesn't even have to be laying on the hands. So that even means like, so basically what it's saying is like a warrant is also a form of imprisonment. A lien is a form of imprisonment, right? You got to think about that. All right. So thus, it says the only essential element of the actions are detention or restraint against one's will and the unlawfulness of such detention or restraint. So in the treatise of the law of torts, Judge Cooley states false imprisonment is a wrong akin to the wrongs of assault and battery and consists in imposing by force or threats an unlawful restraint upon a man's freedom of locomotion. Man, that is a heavy word, locomotion. So that automatically goes into the right to travel as well, right? That is part of locomotion. So, and I want you to understand this as well. See, this goes back to saying that there is no earthly authority that has the right over your divine consciousness. Your consciousness is what's sovereign over this body. There should be nothing restraining you from doing what it is that you want to do in this particular body, right? Drop some ones and let me know y'all with me, man. Drop some ones. That was just powerful, right? That was powerful right there, right? That was real powerful, right? Drop some ones with us. Let me know. All right, so now it says every confinement. So in Blackstone, in his commentaries on the law, states on this matter, every confinement of a person, every keyword, everybody drop down every. Put every in the chat right now so I can know y'all know. So y'all ain't got to ask, well, does it matter to this? No, it said any and every. Any and every. So every confinement, right, of the person is an imprisonment, whether it be in a common prison or in a private house or in the stocks. Man, listen, why did it say or in the stocks? See, now that's going back to like chattel and all of that type of stuff that we be talking about, right? Think about this, right? Or even by forcibly detaining one in the public streets. Oh, man. Oh, man. What did they just say to us? So, now, it says this. Thus, any type of detainment or confinement of a person or restriction of deprivation of their liberty or freedom of locomotion where he is compelled to remain where he does not wish to remain or to go where he does not wish to go is an imprisonment. Man. So the only question thereafter is whether or not the imprisonment is what false. So they just gave you every idea of what an imprisonment is. Now we just have to determine, is the imprisonment considered to be false? Okay, so the only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and the synonymous with unlawful. A false arrest is one means of committing a false imprisonment. So in describing false imprisonment as being the unlawful restraint of liberty of the citizen or of primary right of freedom of locomotion, the Supreme Court of Idaho also stated imprisonment is any restraint, again, they go any restraint of the personal liberty of another and prevention of his movement from one place to place or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority, right? So, in reviewing several textbook definitions of false imprisonment, the Supreme Court of North Carolina stated false imprisonment is the unlawful and total restraint of the liberty of the person. The imprisonment is false if the sense of being unlawful. The right violated by this tort is freedom of locomotion. It belonged historically to the class of rights known as simple or primary rights. The theory of law is that one interferes with the freedom of locomotion of another at his own peril, right? So that means that if any, they enter by them restraining you in any form, they're entering at their own peril. Like this is at your own risk. You better know what you're doing, right? That is the absolute truth. So, a rather complete description of what does and does not constitute false imprisonment was given by the Supreme Court of Kansas as follows. So, listen to this, right? False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed with words alone, even words alone, or by acts alone, or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined with a prison or within walls, or that he be assaulted or even touched. It is necessary that there should be any injury done to the individual's person or to his character or reputation. Nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intention. Nor is it necessary that the act be under color of any legal or judicial proceeding. All that is necessary is that the individual be restrained of his liberty without sufficient legal cause, therefore, and by words or acts which he fears to disregard. Bro, so that's just like when they be walking up on y'all and say, hey, let me see some form of identification. And then you'd be like, okay, but why? What's the crime? And then you'd be like, well, and am I going to be under arrest if I don't give you some form of identification? And then they say, well, yeah, you're detained. Boom. Right then and there, you are in prison. Now, the only way they can imprison you is if they see you and suspect you of committing, in the act of committing, a felony crime, which you're going to keep read in the future. They have to catch you in the act of committing a felony crime. Felony. Like, you got to pay attention to this stuff, right? So, false imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. So, no fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is a false imprisonment. Simple. Just like that. So false imprisonment is the name of the category for the torts that unlawfully deprive or interfere with the liberty of a person. So under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, in jail, or other location. Definition of false imprisonment usually comes from unlawful restraints of this nature. So false imprisonment has been well defined or meant to be trespass committed by one man against the person of another by unlawfully arresting him, detaining him without any legal authority. So the law sets such high value upon the liberty of the citizen that even an attempt to unlawfully arrest is esteemed a great provocation, right? So all the authorities agree that an arrest may be made either with or without any physical force or actual touching by the officer. Thus, any illegal restraint of one's personal liberty by the act of another gives the person cause of action for false imprisonment against the one causing the illegal restraint. So prima facie, any restraint put by fear or force is unlawful. Did you hear that? So any restraint put by fear is considered false imprisonment. See, you got to understand this, guys. If they pull you over right now and everything they do is a tactic of fear and they end up having to let you go because they had nothing, that whole ordeal is considered false imprisonment. Drop some ones if you're with me, man. That's powerful. Drop some ones if you're with me, man. Let me know. Let me know. Because I don't think y'all understand the depth of what it's saying to you right now. Every time they let y'all go, it was false imprisonment. Every time. If you go to if you go to if you go to court, you can prove false imprisonment, and it could be malicious prosecution, which we're going to get into in a minute. But yo, this is serious, right? This is very serious, right? Y'all need to understand what they're telling you here, right? So, false imprisonment is necessarily a wrongful interference with the personal liberty of an individual, usually made by an arrest, and physical custody or restraint is not essential to the effectuation of the arrest. So, if an officer tells a person that he is under arrest, and he thereupon submits himself to the officer, going with him and obeying his orders, such person is deprived of his liberty. And if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure, nor any resistance, the intention of the parties to the transaction are to be considered. In such a case, there must be an intent on the part of one of them to arrest or restrain the other, and the intent or the part of such other to submit under belief and impression that submission was necessary, right? So the following definition will provide further insight in the nature and elements of false imprisonment. Now check this out. False imprisonment is the unlawful restraint by one person of a physical liberty of another, and is, as here used, the word false seems to synonymous with unlawful, right? So any exercise of force or express or implied threat of force by which in fact the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is an unlawful arrest, detention of person without warrant or by an illegal warrant, or a warrant illegally executed. Any restraint. So listen, false imprisonment is the unlawful arrest or detention of a person without a warrant or by a legal warrant. So it's false imprisonment if they arrest you without the warrant on the scene, is what they basically selling you. So when they pull up and say, hey, they just pulled you over, and they say, hey, you got a warrant for your arrest, and they arrest you without the warrant being on the scene, that's false imprisonment, ladies and gentlemen. That's exactly what it's telling you, right? All right, so understand that. All right, so any force, I'm going to go back and read it again. Any exercise of force or expressed or implied threat of force by which, in fact, the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person without warrant or by an illegal warrant, or a warrant illegally executed. So any restraint, however slight, upon another's liberty to come and go as he pleases constitutes an arrest. Man, that's something. So that's why, like, y'all gotta know this. Like, all this stuff be false arrest. If they take the dog, stop you, run it around your car, they don't find nothing, false arrest. Like, and that is automatically a violation of due process law. All of this is considered to be false arrest. So the tort or wrong of false imprisonment occurs the instant that one is restrained in the exercise of their liberty. There is no unreasonable length of time for a restraint before the tort can be claimed. So it could be 2 seconds. It could be 1 second. It doesn't matter. So false imprisonment at common law and elsewhere consists in the unlawful detention of the person of another for any length of time whereby he is deprived of his personal liberty. So where two people are traveling in a car, listen, I'm glad they already talking about this. So if two people traveling in a car and stopped by the police, and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment. How many freaking times does that happen? We watch this on TikTok and all of this stuff right now today. So what I'm saying, we're watching acts of treason, to be honest with you, according to this, right? Drop some ones if you with me. That's powerful. Man, drop some ones, yo. Drop some ones. Let me know y'all with me. As my dad used to say, good God Almighty, ain't God all right? Straight up. Man. So, I really want y'all to listen, because this is something real serious. So, again, they're in the car. The one that was put in the car is considered to have to wait, the officer doing so is guilty of false imprisonment. So even though the person was in the police car for less than a minute, it was an arrest, as the officer had no authority for confining him in the car. Even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. Do y'all? I don't think y'all hearing what we saying right now. You feel what I'm saying? Like, look, I got to let y'all see. Let me. Do y'all see my face? Are y'all listening to what we are reading right now? Do y'all understand what's being said to you right now? Do you know how many times this happens over and over? And I told y'all, when the people start learning the law, boy, these people gonna be held to a higher accountability than you ever could imagine. I promise you. It would be none of this nonsense that's going on. But in order to stop this nonsense, you got to know the law. Remember, the law is a two-edged sword. Yes, it is. They're governed just as well as you are. We're all governed by God, and nobody is exempt. And you got to understand that part, right? You definitely have to understand that part right now, today. Okay? Now, they just told you, even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. Well, one is told to stay in the car by an officer, though it be only for 10 seconds. It's an arrest. Time duration is not a factor in making an arrest. So, false imprisonment is defined as an act which directly or indirectly is a legal cause of confinement of another within boundaries fixed by the actor for any time. So no matter how short in duration makes the actor liable to the other. When one is approached by an officer and questioned about his identity and action, this is only an accosting, not an arrest. So once one is approached by an officer and questioned about his identity and his action, this is only an accosting, not an arrest. So he can question you about the identity. He can even question you about the action. Question is not the problem. It's when they say that if you do not give me your identity, then you will be under arrest. Right then, you're detained. All right? Drop some ones if you understand that. Drop some ones, because I need to clear that up for you. It's not the fact that they're asking. They can ask, but they cannot hold you in any form of detainment if you choose not to answer or to choose not to identify, right? You have a right to privacy at all times. Yes. You got a right to privacy at all times, family. This is very, very important for you to understand. Okay? So, now, damages and liability here, family. What is the damages and liability? So, one who interferes with another's liberty of locomotion does so at his own peril, and all who do so without lawful authority can be sued for the trespass upon liberty and loss of time. Bro, I promise you, if you sue these people for every time they do something wrong, they will stop this shit. They won't be able to feed their families at all. And all of these city polices, etc., all these are municipals, yo. They're businesses for profit for the city. That's it. And if you understand that part, then you got to know that, hey, just like they came, they can go. I done seen many close. I done read about so many of them having to close, right? To shut down, right? To dissolve. So I'm telling y'all, this stuff will stop. And it's another, like, we'll get to that in a minute. Since false imprisonment is a wrong suffered by a person, the person is entitled to receive a remedy for damages. Not only is a person entitled to receive a remedy for the deprivation of his liberty, but also for any other damages that are a result of that deprivation. False imprisonment was an indictable offense at common law. A relief by the party agreed was obtained by an action for trespass, right, with force and arms. The illegal arrest of a person without a warrant, or under a invalid warrant entitles him to compensation for the damages sustained by reason of the false or unlawful imprisonment. The general rule of damages in cases of false imprisonment is that a person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. So again, I keep telling you guys, a police officer cannot harm you because it's just a title, it's a position. But that actual individual, old Scott, Brad, Michael, Jeff, whatever his name is, Cindy, whoever, doesn't matter. That's who can cause you the harm. That's who held liable. That's who hold our responsibility. And then you can actually sue the actual department for what? For lack of training. See, they're responsible for that part. And see, that's where that comes in, right? So drop some ones if you're with me. Drop some ones if you're with me. Let me know. All right? So do keep that in mind. Keep that in mind, right? So the plaintiff is entitled to recover damages for what the party wrongfully did in an action for trespass, assault, and battery and false imprisonment. The court held that the plaintiff could recover not merely for the time the constable was bringing him to jail, but for the whole period of his imprisonment. Oh, the whole entire time. And that means from the time he put on the cuffs all the way to the time you was walked out the door. And in the Mandeville versus Guernsey, the court said the arrest being wrongful, the defendant is liable for all the injurious consequences to the plaintiff which resulted directly from the wrongful act. So unlawful interference with or injuries to the liberty of a citizen is a violation of his natural, inherent, and absolute rights, which damages results as a legal consequence. So a false imprisonment generally includes an assault and battery, and always at least a technical assault. So an unlawful arrest, imprisonment, and prosecution of a person can cause that person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress or anguish, humiliation of mind, shame, public ridicule, invidious publicity, public disgrace. Some of these damages overlap to some degree, but all can and have been claimed in false imprisonment suits. That is a lot. That's a lot, right? Upon the subject of damages, the law specifies two kinds of damages or divides them into two classes. There are what are called actual damage, and then there are what are called punitive damages. So actual damages are such compensations for injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none were intended. In a false imprisonment, they could include the pain and suffering which the average citizen would be supposed to suffer under which circumstances. They further can include the physical discomfort and the sense of shame. Listen, the wrong and outrage. I keep telling y'all need to learn, hey, your feelings get hurt. You were shamed in front of everybody, right? You went to jail, and you know how that looks, right? It looks crazy. And then you got to understand, like, this is what I say, like, when they put certain cases out about people, like, even when they win those cases, it still paints a picture, like, that you feel like, you know, to some people, it's like he did it still. Like, even though OJ won, it's like, bro, he is what we call, you know, yeah, he one of those, right? He's a like a Michael Myers or something, but I'm just saying, I don't want to say the word, but I'm just saying, like, that's what it means, though. So y'all got to understand that part. Like, that picture is painted on you forever, no matter what you want or not. So you have to understand that part. And it is your right in that to make sure that any form of defamation of your character, you have the right to receive everything on that, right? So do know that. Do know that. Okay? So this also goes into punitive damage are those that grow out of the wantonness of atrocity or aggravated by the act. They are the injuries and sufferings that were intended or occurred through malice, carelessness or negligence amounting to a wrong so reckless and wanton as to be uh, without excuse. Okay. There are also called exemplary damages. Anyone who assists or participates in an unlawful arrest or imprisonment is equally liable for the damages caused. Thus, where a man was illegally arrested by a police officer and was placed in a patrol wagon in which he was taken to the central station, it was held that two officers in charge of the patrol wagon were liable along with the arresting officer for false imprisonment. Wow. So they all were held. Again, they're all held accountable. All right. Malicious prosecution. Now, this is the difference between false imprisonment and malicious prosecution. So again, man, y'all hit the share button, show some love, man. Share this out here to the people, man, because I'm out here sharing it with you. So, show some love, man. Extend the love. So what is malicious prosecution, right? In many cases of imprisonment or wrongful arrest, there has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the two charges are not interchangeable or synonymous. There is a fundamental difference between these two charges. They are made up of different elements enforced by different forms of action, are governed by different rules of pleading, evidence, and damages, and are subject to different defenses. One description of malicious prosecution is as follows. Malicious prosecution is an action ex delicto for the recovery of damages which have proximately resulted to person, property, or reputation from a previous unsuccessful civil or criminal proceeding, which was prosecuted without probable cause and with malice. So that literally means that if they freaking lose and they fail to prosecute you, then it is considered to be malicious prosecution. In an action of this type, the burden rests upon the plaintiff, the one bringing the suit, to establish each and all of the following propositions before being entitled to recover to wit. He was prosecuted in a proceeding or civil suit. The defendant instigated such prosecution. The prosecution terminated favorable of the accused. The defendant acted without probable cause. Defendant acted with malice, and damages that were caused. So again, that's just like the prosecutor bringing something against you, knowing that it is under a color of law, and it's violating your constitutional rights and your liberty, which has everything to do with your locomotion, right? So if they continue to bring that forward, knowing that the warrant was not at the scene for the arrest, then it's considered to be malice because you knew better, right? There is no such thing as ignorance of the law, right? You have to understand that. You got to understand that, right? So it says that basically, if he was prosecuted in a criminal proceeding or civil suit, the defendant instigated such prosecution. The prosecution terminated favorable to the accused. Defendant acted without probable cause. Defendant acted with malice, and damages that were caused. So in the Indiana case arose where a man sued several officers for unlawfully arresting and imprisoning him in the county jail and without any charge preferred against him. The defendants insisted his complaint was bad as it did not allege that the imprisonment wasn't malicious and without probable cause. The state Supreme Court rejected this claim. There is a marked distinction between malicious prosecution and a false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is a malicious prosecution. If it has been extrajudicial without legal process, it is false imprisonment. So an arrest or imprisonment can be malicious or false, but not both, okay? Has to be one or the other. In a case of malicious prosecution, the arrest or detention is procured from malicious motives and without probable cause. And I understand why. Like, you're hitting them with two things that's about the same thing, about being detained, right? But it says, but was done under lawful process, whereas in false imprisonment, the detention is without proper legal authority. Okay? One may be legally arrested for some alleged reason, but done maliciously. Okay? If he is found to be not guilty, he then has a case for malicious prosecution, but not for false imprisonment. If the arrest is not pursuant to legal forms of law, then whether he is guilty or not, he has a case for false imprisonment, but not malicious prosecution. If this is done with malice, it would add punitive damage to the suit. So again, it's just like saying that, like for instance, we can just say, let's say that they arrested you according to some form of statute and code, but then when you get to court, like they legally arrested you, but lawfully they didn't. And then when that's why they have to dismiss the case because of, some constitutional right that you may have. That is malicious prosecution. All right. Just to understand that. So drop some ones to make sure you guys understand that part. Drop some ones. Let me know that you guys know. All right. Let's keep it moving here. Okay. All right. So basically, it says, let's see, if he is found not guilty, we already read that part. So in describing the distinction between the two charges, the Supreme Court of Oregon stated that the foundation of the cause of action for false imprisonment is the right which even a guilty man has to be protected. Against any unlawful restraint of his personal liberty. So while a malicious prosecution's case is founded upon the right of an innocent man to be compensated in damages for any injury he may sustain when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strict forms of law. So in other words, the want of authority is an essential element in the action for false imprisonment, whereas malice and want of probable cause are the essentials in the actions for malicious prosecution. Okay? So they need authority in order to make a arrest. So what would give them the authority to make the arrest? Based upon some felony act that you commit by breaking the form of law. Now they have the right, or they have a warrant. And even if they arrest you on the spot, they have to take you to see a magistrate to determine whether they can't even book you. Like when they do all that booking and stuff like that, that is a violation of due process, right? They have to determine first that it's even considered a warrant for your arrest. Then once the warrant is made, then they can start booking you, etc., because now you are considered to be charged. All right. It's a criminal charge. And by that time, any form of criminal charge has to be charges of the state for and on behalf of the people. Drop some ones if you understand that. Okay. Drop some ones if you understand that. So, somewhat different to wrong of malicious prosecution is the charge of abuse of process, which is the misuse of legal process for an ulterior purpose in which malice or ill will may be also a factor. All right, so let's go. Before we go into this, man, we finna go into arrest without warrant. And this is very important because we finna get on the other behalf of this class. So, you know what I'm saying? I need to check y'all, man. Check y'all vibe right quick. Let's see where y'all vibe is right now. And let's turn up for a second. Drop some ones. Hit the share button, man. Stretch your arms out a little bit. You know? Don't let my voice door y'all out. So let everybody know what we on tonight. False imprisonment, baby. Yes. Man, it's really something though, just learning this, right? Yeah, it's really something. Because a lot of people don't know this. You know how many people we got go to jail on this every day? This is like insane. Because this happens a lot. and they do stuff with, well, you know, they play upon your ignorance. Remember, and they always say that you basically, there's no ignorance of the law. Everybody has to know the law. You know, ignorance of the law is inexcusable. So, and that will be used against you. And you have to understand that. So, I just really want y'all to think about that because that's really something. All right, so now we're going to talk about the law of the land. Notice it say the law of the land, right? Law of the land. So the authority to arrest without warrant was rather limited and well defined at common law, a law which has been made part of our constitutional law and the due process provisions. Now, for those of you that don't understand common law means like when the judges have judged over a situation. And it is a situation that must be transpired throughout the whole entire union. Okay? So that's what that is. Okay? So here we go. Let's jump in. Let's keep going, right? That's the way common law is. So a law which has been made part of our constitutional law and due process provision. The common law rule on arrest is based on common sense. Literally, common sense. You hear? You see how they said this? They let you know, like, the law is based on common sense, family. Do you guys got common sense? As general rule at common law, an arrest could not be made without a warrant. Thus, the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter in delivering an opinion for the Supreme Court of Michigan as follows. The law governing this case is elementary, except for a breach of the peace committed in the presence or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony. A police officer has no authority to arrest without warrant. So again, let me read this to you again. The only way they can arrest you, okay, is to have reasonable ground to believe that the person arrested is a felon or is about to commit a felony. A police officer has no authority to arrest without a warrant. The objective in this law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrest had to yield to the liberty of the citizen. The liberty of the citizen is too sacred to be left to the arbitrary will of men. See, it's not. There is no arbitration in the streets, yo. We got a law to follow here, right? Everyone knows that felonies are the most common felonies. All right, are murder, the R word, kidnapping, the S word, arbitration, abortion, and treason and arson, right? A breach of peace is obvious and well known. Therefore, everyone's liberty was safe since all knew for what they could and could not be arrested. All right, but where is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact, or if the law or arrest can be charged by statutes, right? So by the due process clause, the common law governs what the law on arrest is in this land, and where it exists, the most statutes can be is declaratory of the common law. So if there is no direct language in the Constitution directing what procedure or process to be followed, the common law is to be due process of law followed, not a legislative statute or city ordinance. I'm going to say that again. The actual common law is to be due process of law followed, not a legislative statute or city ordinance. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. Right? It's guilty of false imprisonment. Think about that, right? The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive office. First, to initiate a suit against one who unlawfully deprives you of your liberty, and there an example of a summons and a complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this actual matter. So this would be one, and it says, you are hereby summoned and required to serve upon the plaintiff and answer to complaint herein which serve upon you 20 days after service of summons upon you, exclusive day of such service. If you fail to do so, judgment by default will be made against you for the relief, right? And this is the actual complaint. So I want you guys to listen. On September the 30th, 1992, plaintiff was traveling in his automobile on a public highway called I-35 West between Richfield and Minneapolis, and going northbound when stopped by the defendant acting as a highway patrolman, an employee of the state of Minnesota. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board or commission and is not required to be a licensee. Oh my God, did y'all hear what they just said? The defendant insisted the plaintiff must have the said license. The defendant then arrested, searched, and handcuffed the plaintiff without warrant, and over his objection that the defendant's acts were in violation of the plaintiff's rights and the constitutional provision of due process of law. The defendant gave no specific charges to the plaintiff for his being stopped or for the arrest, nor did he advise him of his rights as shown in the defendant's field report, which contained only traffic misdemeanor charges. A copy of this report and an official complaint was received by plaintiff 2 months after the arrest. The defendant brought the plaintiff to the Hennepin County Jail, where the defendant knew the plaintiff would be subject to booking, which included fingerprinting, photographing, and confinement for an indefinite period of time, and possibly be subject to other type of assaults and batteries. So, further, the plaintiff, by his own admission, had made no attempt to bring the defendant before a magistrate or judge when he had full opportunity to do so, being that the arrest occurred at 10:15 a.m. on a Wednesday. So do you hear how they have to bring you to the judge themselves? And the one who arrests you has to bring you to the judge. It cannot be a jailer or anybody there reporting you to the judge the next day. I know they try that 72-hour bull crap, but it's bull crap. They can't do that. It has to be immediate. And, well, 48 hours or whatever they say. But it has to be immediately. And I'm serious when I say that. So it says he had every opportunity to do so. The arrest occurred about 10:15 a.m. on Wednesday. The defendant, acting on his own record and without warrant or court order, had the plaintiff's automobile towed to an impound lot and put it on a hold order. Ooh, man, this is getting good, right? So what plaintiff realleges paragraph 1 through 7, right? So on September the 30th, 1992, the defendant, without warrant or due process of law, Minnesota Constitution, Article 1, Section 10, unlawfully arrested the plaintiff and, acting contrary to law, did falsely imprison the plaintiff, depriving him of his liberty. As a result of the defendant's false imprisonment of the plaintiff had his right to liberty violated, suffered mental anguish, a loss of time and wages in his work, and a discredit in his reputation by his failure to attend scheduled meeting. So, also, false imprisonment, plaintiff realleges paragraphs 1 through 7. The defendant, upon arresting plaintiff, brought him to the county jail for the purpose of booking and detaining him, and by his own admission made no attempt to bring plaintiff before a proper judge or court as required by due process. So the acts of the defendant in deciding how to deal with the plaintiff after his arrest and failing to take him to a judge or a court to so decide constitute false imprisonment by the defendant under the law of the land, Minnesota Constitution, Article 1, Section 2. Man, I don't think y'all don't understand what y'all listening to, man. Y'all supposed to be sharing this with everybody. If you love your people, share this. This is free. that y'all are able to see this, man. Go get a lawyer for what? What you need a lawyer for? Only you the best one to tell your story. You just need to understand and know your rights, right? So let's go. Let's go. Count three: assault and battery. Due to the unlawful acts of the defendant, the plaintiff suffered a series of assaults, batteries upon his person, including arrest, handcuffing, imprisonment, physically search, forced fingerprinting, and booking procedures and harassment. All right, they sought out $10,000. Right. All right, so if it was $10,000 then, it's $100,000 today, and that was back in '92. All right, so '93. So yeah, it's 100,000 a day. The way economy and the price, the dollar, and all of that dropped and went up. So yeah, we know what time it is. All right, so here is the memorandum of law. All right. Comes now the plaintiff, Charles A. Wiseman, a free citizen of the state of Minnesota, who respectfully presents and submits this memorandum as evidence of proof of prevailing and controlling law regarding the matter now before the court here. Interesting, Charles. Arguments and statements of law. The defendant claims that his arrest of the plaintiff without warrant for the violation of 2 traffic laws was lawful, right? Defendant claims that he is authorized by statute to make arrests for any violation of laws of the state, whether they are misdemeanor or a felony when committed in his presence. The facts of this case led to the conclusion of law that the defendant did not have any lawful authority to arrest the plaintiff. The defendant had no warrant for the arrest of the plaintiff, and he alleges that he only saw a plaintiff commit a misdemeanor, in other words, traffic violation. There was no claim of a felony committed or a breach of peace committed. A common law under the provisions of due process of law, such an arrest without a warrant cannot be made. Since the arrest deprived the plaintiff of liberty by an act not pursuant to due process of law, the arrest is unlawful. Due process is not determined by the legislator. It is manifest it was not left to the legislative power to exact any process which might be devised. The due process article is restraint on the legislative as well as on the executive and judicial powers of the government and cannot be construed as to leave Congress free to make any process due process of law by its mere will. All right, Murray's Leslie versus Hoboken Company, I guess, 1855. The Constitution of Minnesota declares that no person shall be deprived of life, liberty, or property without due process of law. Minnesota Constitution, Article 1, Section 7. The words due process do not mean anything which the legislative may see fit to declare to be due process of law. State ex rel versus Billington, right? So due process was intended to preserve established fundamental rights by requiring that they cannot be deprived except by the established modes of law as existing under the common law. This guarantee that the government shall follow a specified and pre-existing rule of conduct, process, or procedure is in itself a right the citizen held at common law and was claimed by the colonists in early America. Thus, it is clear that the common law is the foundation of that which is designated as due process of law, right? The Constitution guarantees the pre-existing rights and procedures in due process provisions. What is due process of law may be ascertained by examination of those settled usages and modes of exceeding proceedings existing in common and statute law of England before immigration and ancestors, y'all. So listen, y'all, I'm just telling y'all, like, everything that you're hearing here is the power. I'm not going to keep reading this part because there's a lot in the memorandum that I don't want to read. So we're going to go back and get out the memorandum. And I'm finna show y'all something because now we got to know what the breach of peace is, right? We got to understand what the breach of peace is because everything in the memorandum is just going back saying what we've already said. So we already know what it is to be in false imprisonment, right? We know what it is. And as you can see, it had everything to do with processing and all of those things. So now we have to declare what breach of peace is, right? All right, so what is a breach of peace? A breach of the peace may be generally defined as a violation of the public order which amounts to a disturbance of the public tranquility or by inciting others to do so. It is clear that not every misdemeanor is a breach of peace. So to constitute a breach of the peace, there must be some violence or harm existing or threatened to occur to person, property, health, or morals. Affrays, assaults, riotous conduct, or destruction of property make up the largest part of what can be called a breach of peace. Thus, in the majority of cases of breach of peace, some actual violence is present. In some states, there has been attempts to expand the meaning of breach of peace to include all indictable misdemeanors. But this it must be confessed is doing serious violence to simple expressions easily and well understood, which is true. So some of the type of breaches of the peace are described as follow. A breach of peace includes acts of public turbulence, acts of violence, or tending to produce violence, or tending to incite violence, disturbance of the public tranquility by yelling, hollering, or uttering loud and vociferous language, profanity, I guess, making disturbance noises on a public street by one in a state of intoxication, wanton discharge of firearms in public place, engaging in a fray or in an assault, uttering abusive, profane, indecent, or otherwise provocative language, and discussing what constitutes a breach of peace. The Supreme Court of North Carolina held a breach of the peace is a public offense done by violence or one causing or likely to cause an immediate disturbance of public order. So breach of the peace are acts which are, I guess that's Malone and say, being wrongful or evil by their nature. So thus acts which are, or those acts made wrong merely by a statute cannot be classed as a breach of the peace. Those acts which constitute a breach of the peace have been settled throughout the course in common law. The legislator cannot declare any act they choose to be a breach of peace. The nature of the act determines if it fits the common law definition of breach of peace. So the acts that are only Malone prohibita, which means include liquor prohibiting laws, traffic laws, labor laws, health laws, food laws, building codes, zoning orders, safety acts, gang laws, and very many other police regulations. Without a statute, most of these acts constituting these offenses would be innocent acts, right? So a parade on the street is not of itself a breach of the peace, though it could constitute one. The carrying of arms in a quiet, peaceable, and orderly manner concealed or on or about the person is not a breach of peace. So again, that goes back to your right to bear arms, your Second Amendment. Man, they can't arrest you just for having your gun. You have the right to self-defense. Okay? And if they try to arrest you based upon you having a gun, then number one, they gotta have a warrant. Number two, they need to take you straight to the magistrate. Number three, they also have to prove that you had willful intent to go and cause harm, that you were going to make war, not defend peace. So that's the difference. And you can be any right to bear arm case like that, which is why most of these states are saying that, oh, it's an open carry, right? Yeah, of course, it's always been that. But it's up to you to understand, because most of these statutes is already violating, right? And they know that. All right. So also, let's see. Nor does an act of itself tend to a breach of peace. A mere trespass is not a breach of the peace and does not impose criminal liability upon the wrongdoer. Driving an automobile while intoxicated constitutes a breach of peace. Indecent exposure, as where one is walking in public naked or nearly naked or in indecent dress, is disruptive of the morals of society and constitute a breach of peace. Blasphemy of Christ or Christianity in public is a breach of the peace. So we can just say blasphemy in any form of religion. Like, you can't down and conquer and cuss out people's type of religion and all of that. Like, it's a form of, what do you call it? And let's say those people start losing members and stuff. It's defamation. So, like, they could eat you alive in lawsuits on that type of stuff. So I wouldn't do nothing like that. So a mere violation of public decorum or a penal law does not constitute a breach of peace. Conduct merely amounting to a nuisance is not per se a breach of peace. The sale of 15 dynamite caps to a 15-year-old boy did not constitute a breach of peace. And theft is not in its nature a breach of peace. A charge of disorderly conduct is a broader term than a breach of peace, because a person who commits a breach of peace is necessarily guilty of disorderly conduct, but also disorderly conduct is not necessarily a breach of peace. So breach of peace is a common law offense, but is not itself a specific offense. Thus, in charge or indictment, the specific offense must be specified. All right. So, only arrest that can be made if the struggle for government to claim and exercise greater powers of arrest, it has unlawfully attempted to apply the common law for the breach of peace arrest to allow misdemeanors. The general rule of law under the common law for the arrest of misdemeanor offenses amounting to breach of peace is stated as follows. So, in case of misdemeanor, a peace officer, like a private person, has a common law no power or of arresting without a warrant, except when a breach of peace has been committed in the presence of there is reasonable ground for supporting that a breach of peace is about to be committed or renewed in his presence. So an arrest can only be made to suppress and prevent the breach of peace, and if the act ceases, there is no longer justification for the arrest without warrant. So a constable cannot arrest, but when he sees an actual breach of peace, and if the affray be over, he cannot arrest. And where a breach of peace has been committed and war was, the constable must proceed in the same way as any other person, namely by obtaining a warrant from the magistrate. So again, what they must do? They must proceed in the same way as any other person, namely by obtaining a warrant from the magistrate. Man. So the rule for arrest without a warrant involving misdemeanor was stated in the article in Michigan law. Listen, man, y'all better pay attention to this part, man. Like this is where it starts getting serious at. So those of you that are holding on to this, because we're gonna get through this tonight, but you need to understand this. So the rule for arrest without warrant involving misdemeanor was stated in the article Michigan Law Review as follows. So neither a peace officer nor a private citizen may arrest a person for a misdemeanor, which is not a breach of peace. In regard to this rule, it was stated. So neither an officer nor a citizen may arrest for a misdemeanor which does not amount to a breach of peace, even though it occurs in his presence. For as for an example, talking loudly in the street in the presence of an officer who ordered the parties to be quiet, an arrest without a warrant was not justified, nor where D, which is a person in the presence of a peace officer, was turning toward the wall for a particular purpose of relief in the streets, or where he was disturbing a public meeting or obstructing the free passage across a bridge, or refusing to move on the sidewalk at the request of an officer, or fraudulently substituting a smaller for a larger check, or fraudulently evading payment of a railroad fare, or obtaining a billboard on the sidewalk, or insulting the head of the house in the presence of his family, or assembling to witness as a Sunday ball game or a movie or show. It is a common rule that an officer cannot arrest for a breach of peace after it has ended. When a breach of the peace ceases, the reason for the arrest ceases, that being to stop or prevent the breach of the public order. So that's what it comes to when it comes to the actual breach of peace. That warrant has to be present. All right? Get that warrant present. So what are the conditions on felony arrest? It was regarded upon the common law to be a right and duty for a citizen to arrest one he sees committing a felony without a warrant. As stated by justice, all persons, whatever, who are present with a felony is committed or a dangerous wound is given are bound to apprehend the offenders. So to arrest a person for a felony not witnessed by the officer, he must be able to conclude from the facts then existing that certain persons did not commit the felony, so that any prudent person would be led to believe likewise. So an arrest for a felony based upon suspicion, belief, or rumor can never be justified for any cause whatsoever, not even by a warrant, and such an arrest be lawful. So again, they can't just, you got to know. Where there is a felony and it is passed, the officer is justified in arresting, though no offense has been committed, right? All right. Yet he must have had a reasonable cause to suspect the one apprehended. To follow arrest for suspicion, even if the case of felony would make everyone susceptible to arrest who the officer might choose to believe to be likely or possible perpetrator of the crime. It would infect an amount of general warrant. In the hands of any officer, a concept which was found to be so aberrant to the founding fathers of the American Revolution. So again, like this just means like the officer can make the arrest, but that is the whole purpose of taking the actual individual to the magistrate, because right then and there is where the magistrate determines if they have enough evidence to even consider a charge. If there's not enough evidence, then you must be set free. And that's how that's supposed to work. Not you being taken, booked, fingerprinted, wait for 3-4 days. That's bullshit. That, like, you're not promised the next minute. So justice has to be swift. Justice can never be prolonged in any shape, form, or fashion, right? So understand that all arrests for felonies not seen or witnessed by the officer or citizens making the arrest have the burden to justify the arrest. If any felony arrest by a private citizen, he must justify the arrest by showing that the felony had actually been committed and that he had a reasonable grounds for believing the person arrested to be guilty. An officer is required only to show the probable cause existing for making the arrest and need not show that a felony action occurred, though such proof could serve as justification. In all other arrests, probable cause is not a factor in justifying arrest without a warrant at all. Right? At all. It is well settled in common law that an officer or private person without warrant may lawfully seize and detain another in case where a felony was about to occur. So if two persons be fighting and there be a reason to fear that one of them will be killed by the other, it will be lawful to part and imprison them till their anger shall be cooled. All right? And private person may justify breaking and entering the plaintiff's house and imprisoning his person to prevent him from murdering his wife. And that's facts. Right? That is because you are seeing them in the act and they are about to commit the felonious crime if you sit there and watch. You shouldn't just sit there and watch somebody die, right? Which we often have done over the past years of watching officers kill people. And I'm not telling anybody to jump in the middle of that shit because it ain't sense of you dying either, but it just goes to show you of what has been taken right along. All right, so this is going to be the last thing we're going to go over, defenses to unlawful arrest. So what I want you guys to do is hit the share button, drop some ones, and let me know that you guys are still alive and responsive out there right now. Let's get them vibes up. Let me make sure y'all here with us. Where y'all at? Are y'all still with us right now? Let me know. Y'all loving class tonight? Yeah, that's what's up. That's what's up, man. If this is your first time with us, man, let us know, man, and make sure that you stay. Got some things for you so you can join our free classes and stuff like that as well. So appreciate the roses, appreciate everything that you guys are giving, all the gifts and stuff like that. Appreciate the stars that you guys give as well. So definitely appreciate it. Yeah, I actually made this beat myself, so appreciate it. Yeah, appreciate it, my brother. All right, I think y'all ready now. Y'all think y'all ready, man. Let's get through this last little part here, man. We're going to enjoy this. All right, we're going to enjoy this. So, man, this has been a great understand. I've taught this class many times, and we're just going to jump in on it. So this section will be of the benefit not only to those who may initiate a suit for false imprisonment, but also for a peace officer, as it further outlines what is the extent of their authority. So to all you great officers out there, you're gonna, if you're paying attention, just listen. This is the extent of your authority and your former colleagues that are with you. Like, you need to make sure that you guys know what's going on so you don't cross that line, right? We want everybody to be safe and have everything for their family and, not get sued for millions of freaking dollars, all because we didn't understand the law, right? All right, so let's go. Suits are usually brought by because there is not a meeting of the minds in regards to the facts of the law of a case. If both parties know the law of arrest and what can and cannot be used as a defense to acts of imprisonment, many lengthy and costly litigations can be avoided. Over the course of the history of arrest, there have been numerous defenses raised against claims of false imprisonment, yet the basic defense for this charge is usually limited to showing that the arrest was pursuant to law, that the one arresting had lawful authority to act. Thus, a valid defense or proper justification for false imprisonment would normally be one asserting the legality of the arrest. As Justice Hand stated, right? The law watches personal liberty with vigilance and jealousy, and whosoever imprisons another in this country must do it for a lawful cause and in a legal manner. Most of the runner's defenses have been due to the misconstruing and the requirements of his suit for malicious prosecution with those required for false imprisonment. So the burden of proof in false imprisonment suits or in allegations of false arrest, it can be no defense that the one who was arrested must prove that the arrest was unlawful in order to prevail in the suit. Due to high regard placed on liberty, all imprisonments of a person are deemed unlawful until the contrary is shown. Right? So in Haileybury Laws of England, in speaking of suits of false imprisonment, it says the plaintiff need not prove that the imprisonment was unlawful or malicious, but establish a prima facie case. He proves that he was imprisoned by the defendant. The onus then lies on the defendant of proving a justification. So the only thing the plaintiff needs to plead and prove is one of two things: either that the defendant made an arrest or imprisonment, or that the defendant affirmatively instigated and encouraged, incited, or caused the arrest or imprisonment when the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant. The law presumes it is to be unlawful. So thus it has been held that a false imprisonment suits the defendant, in order to escape liability, must either prove that he did not imprison the plaintiff or he must justify the imprisonment. Stated another way, the burden is upon the defendant to show that the arrest was by authority of law. In a case where two police officers arrested a man whom they believe committed a felony, the jury was instructed that the burden of proof by a fair preponderance of the evidence was upon the plaintiff to show the arrest and the imprisonment were not justified. This instruction was held to be wrong on the appeal when the court stated, "It was long ago said by Lord Mansfield, a gay lawyer, if he has a prisoner in custody and prima facie guilty of an imprisonment and therefore must justify." So, in Horby versus Doncaster, it was said by Chief Justice Best, where a man deprives another of his liberty, the injured party is entitled to maintain an action for false imprisonment, and it is for defendant to justify his proceeding by showing that he had legal authority for doing that which he had done. So basically what they're saying is if you bring a civil suit about false imprisonment, then the false imprisonment is considered to be true until the actual defendant can show that it's not. So hope you guys understand that part, right? That's pretty amazing to hear as well. Okay. So it's also like right here, where an officer arrests a person without a warrant, the burden rests upon the officer to plead and prove the justification. Otherwise, the arrest is prima facie unlawful. In a case in Iowa, the mayor of the town had instructed the town marshal to arrest a man because he had been reported that he was drunk and he had been disturbing the peace. The marshal arrested the man in his home without a warrant. When the man sued the mayor and marshal for false imprisonment, the court instructed the jury that the burden of proof was upon the plaintiff, the man arrested, to prove that he was not found intoxicated when arrested. On appeal, the Supreme Court of Iowa held that the court announced it an incorrect rule of evidence on the matter, which is true. The Supreme Court, in defining the correct rule, stated, in 2 Bishop Criminal Procedure, subsection 368, it said, in matters of evidence, if the imprisonment is proved, its unlawfulness will be prima facie presumed, but authority may be shown by the defendant in justification. So if the marshal had a valid warrant, this would serve as justification for the arrest and a defense to charge of false imprisonment. Being he had none and he witnessed to no breach of the peace, he had no defense against the charge. So the rule of burden of proofs is the same in a criminal proceeding where any arrest made without a warrant, if challenged by the defendant, is presumptively invalid, and the burden is upon the state to justify it as one not only authorized by statute, but also as one not violated of constitutional provisions, right? The invalidity of the arrest will render the search invalid and the evidence obtained inadmissible. This was so held in Testosterone versus State. So again, man, like y'all, I don't think y'all understand what you're hearing right now. It's very important. There has to be good faith and probable cause. The most common defense raised in false imprisonment suit is that arresting officer acted in good faith or with good intent. This argument of defense is often raised along with the defense that the officer had probable cause. Both of these defenses are often misapplied to the action of the false arrest. Such defenses are more applicable to suits involving malicious prosecution or abuse of process rather than false imprisonment, as stated by the Supreme Court of Iowa. So, false imprisonment is the unlawful restraint of an individual's personal liberty or freedom of locomotion. The good faith of the actor is no justification, nor is the want of probable cause an essential element, as in the case of malicious prosecution. In cases of false imprisonment, the only essential element of the actions are detention and its unlawfulness. Thus, malice and the want of probable cause not to be shown, or are not necessary to a proper cause of action for the false arrest, because again, there's no authority there at all. So even where the unlawful arrest is claimed to have been for the public good, such a defense will not stop damages. So it doesn't matter that they could have thought they was doing the right thing no matter what. Like that ain't stopping nothing, right? It is well settled law that the want of the reasonable or probable cause and the want of malice are elements not entering into the action of false imprisonment. It is so far as actual damages are concerned. So the question of probable cause in its usual sense is not involved in the action for false imprisonment. Again, because there is no authority there from the beginning. So that goes back to say, like, yeah, they might arrest you and feel of the probable cause, but still lack certain evidence and things and violated due process. Like, yeah, you might have been, you got to think about it. They might have saw you or you might have been wrong. But if they violate and do in due process and things of that nature, then it becomes a form of malicious prosecution because they're not supposed to do any form of violating when it comes to the Constitution at all. They're not supposed to be in any form of ultra-virus acts, right? So check this out. Now, let's see. According to the great weight of the authority, existing of probable cause is not an element nor a defense to an action for false imprisonment. So a case in South Dakota developed where a sheriff had, due to mistaken identity, arrested the wrong person as an embezzler upon a warrant, which did not name or describe the person to be arrested. The sheriff alleged good faith and probable cause for arresting the man. All right, the state Supreme Court held that the fact that the sheriff acted in good faith and with probable cause was no defense and may not be taken into account in determining the damages which will compensate the plaintiff. In many cases, officers will try to justify an arrest for a misdemeanor based upon a strong belief that the person arrested is guilty. In such a case, the Appellate Court of Illinois held in the action for trespass and false imprisonment, probable cause, and the absence of malice constitutes no defense. In this form of action, belief the guilt of the party arrested, no matter how strong or well-founded in the mind of the officer or person making the arrest, will not justify the deprivation of another of his liberty. And it is unimportant whether the circumstances will lead a reasonable or prudent person to believe that the accused was actually guilty. So again, it does not matter at all. So in some cases, instead of asserting that the officer acted in good faith, the defense is raised that malice must be proven on the part of the arresting officer. The defense is, however, groundless in the matters of false imprisonment. So in the action for false imprisonment, neither actual malice nor want of probable cause is an essential element necessary to recovery of general damages. Whatever the motives of the arresting officers, they do not cause or bring about a change in the legality of arrest, as was asserted by the Supreme Court of Missouri. So a lawful imprisonment does not become unlawful because of malicious motive, nor does a unlawful detention become unlawful because acted by a laudable purpose founded on good faith. So closely related to the offense of good faith or lack of malice is that an arrest is justified where there is no force or injury done to the person arrested. But as the United States Court of Appeals stated, that does not justify an arrest. All that is necessary to establish false imprisonment is that an individual be restrained of his liberty under the probable imminence of force without any legal cause or justification thereof. It is not necessary to show actual force, threats, or injury done to the individual, person, character, or reputation. The lack of malice, right? The presence of good faith or present of probable cause do not affect the existence of the wrong when the detention is unlawful. So again, guys, it does not matter, right? Does not matter. Okay? So even when it comes to ignorance of the law, ignorance of the fact excuses, ignorance of the law excuses not. Every man must be taken to be cognizant of the law. Otherwise, there is no saying to what extent the excuse of ignorance may not be carried. So everybody can act dumb, but everybody can't act in knowledge. Now think about that, which is what that is saying. We all could sit up here and play dumb and act like we didn't know anything and expect to be excused. But if you're held accountable to know, well, ignorance of the law is inexcusable. You should know this, right? Because it's considered to be what? As I said earlier, common sense. It's common sense. It has been said that unlawful detention or imprisonment does not become unlawful because done out of the ignorance of the law. The Georgia Court of Appeals held that it is no defense that a person pertaining in illegal arrest or imprisonment is ignorant of the illegality of his acts. So listen, all of that stuff talking about, oh, I didn't know, whatever. Yeah, you're held responsible. Okay? You're held responsible. Okay? Now, let's go, man. This is the last one. This is the last one for the night. I think you guys really need to know this. This is the last one of the night. Last call for the knowledge. Last call, guys. Last call. The use of warrant and arrest. Now, when you hear this, this is what's going to tell you of all the wrong they've been doing. Okay? And I want you to think about how many times y'all watch this stuff on think about how many times you watch it on TikTok right now. You can get on TikTok, social media period, and just watch what these officers are doing to people. That is so wrong. Right? And the fact that we're watching it, it means that we're watching the public trust, and we're watching the public interest be broken. And it's only gonna be considered broken when you're aware of it. And when you become aware of it, then now you know that the public interest is broken because you're like, hey, I know this and you're breaking the law. You are harming a fellow citizen, which means that you're usurping powers. And if you're doing it to them, you're doing it to us, the people. See, now you are harming the people, and it should be the people versus you for treasonous acts. Who is causing a harm and breaching the peace, because there is a peace here. Right? Breach of peace goes both ways, guys. I want you guys to start thinking about that. Right? Do you not know an officer traveling 100 miles an hour throughout a neighborhood is a form of breach of peace? That's trying to chase someone. Y'all know that's a breach of peace. I hope. But we'll talk about that later on too. That's some other stuff that we constantly watch happen and nobody's holding them accountable for this stuff. We just watching it, right? So the requirement for warrants and seizure of person or property is an affirmation of common law principles. The Declaration in our Constitution prescribing the mode in which they are to issue reflects the aberrance of the use of the so-called general warrants, whereby easy and arbitrary arrests and seizures were made. So despite such declarations for the security of liberty, privacy, and property, history shows that the executive department has strong tendencies to disregard and violate them, as revealed by the U.S. Supreme Court. Though the police are honest and their aims worthy, history shows they are not appropriate guardians of the privacy which the Fourth Amendment protects. While the Fourth Amendment has been badly violated, we find that the due process of law provision is virtually ignored when it comes to warrants. For the most part, it is the due process provision which prescribes the actual requirement of a warrant for all arrests except where public security allows a warrantless arrest. All right. Warrant to be in possession of the arresting officer. Listen very carefully. I need to know you guys are listening. So I'm gonna need y'all to drop some warrants right now. I need to know y'all here, because this is the most important part of what we speaking on tonight. Need to know you're here. Let's go. All right, continue to share, family. Continue to share. All right, so an arrest warrant is a written order issued by a court or magistrate directed to a peace officer or to a specified private person commanding him to arrest a named person. It is regarded as fundamental law that where one cannot arrest without a warrant, okay, a warrant must be acquired and be in the actual possession of the one making the arrest. Without otherwise, he is not protected by it. The requirement of having the warrant for arrest in actual possession is the common law rule, and thus is part of due process of law, as it is a procedure which deprives a citizen of his liberty. So in a case where a policeman, by direction of a sheriff, arrested an individual pursuant to a warrant, it was claimed the arrest was unlawful since the sheriff retained the possession of the warrant in his office. Okay? Because it was in his office, right? The Supreme Court of North Carolina held that the overwhelming weight of authority for misdemeanor charges is that the officer must have the warrant in his possession. The court stated the following. We find the general rule stated as follows. The warrant must at the time of arrest be in possession of and with the person purporting to act thereunder or of one with whom he is acting in conjunction. So that means if they buddies on the scene, they all in conjunction, they better make sure they warrant there or every last individual can be held responsible for violation of due process law. Right? Man, ain't that something, right? For violation of due process of law, right? Okay. So accordingly, where the warrant is at the officer's house, some distance from the scene of the arrest, or in the hands of another who is not at the scene of the arrest, or in the central office of a city detective bureau, the arrest is unlawful. So it's got to be on the scene, family. You have to be able to examine it, family. Since there was no felony or breach of peace committed in the presence of the policeman, his arrest was deemed illegal despite the fact there was a valid warrant for the individual arrested, since it was with the sheriff who was in another town. The court also said that the good faith of the policeman did not affect the unlawfulness of the arrest. So, man, listen, they cannot snatch you up, right? You know how they be picking up people for warrants. Like, I seen somebody get picked up from a warrant all the way down in Miami. And that's crazy. I think even one of my peoples told me that they was all the way in Seattle and had to go all the way back to Florida, bro. And you know damn well they didn't have their warrant on their hand. That's the thing, right? Man, so I just think about this stuff, right? Literally think about this, right? A Mississippi case involved a warrant that was issued for the arrest of Bill Smith on the reckless driving charge. Under the sheriff's instruction, a deputy went to Smith's home to arrest him while the warrant remained in the sheriff's office. Smith asked to see the warrant for his arrest. The deputy replied that he did not have it with him, but it was at the sheriff's office and Smith could see it when they arrived there. However, Smith said he would have to see the warrant before he would submit to the arrest. Smith resisted the arrest. The sheriff was called out, but came without the warrant. Smith again resisted, but was forcibly taken to jail. The state Supreme Court held the arrest was unlawful. Under the great weight of authority, an officer making an arrest for a misdemeanor not committed in his presence must have the warrant for such arrest in his actual possession if the arrest is to be lawful. Man. In a criminal case involving a violation of a lien, a policeman was given a warrant for the arrest of a man named Shaw. Listen to this. He drove to Shaw house in a buggy. He left the warrant in the buggy being some 150 yards from the house. Dang. The officer went into the house and put his hands on Shaw's shoulder and told him that he had a warrant for him and to consider himself under arrest. Shaw asked what for. The officer replied, for disposing of property under lien, and that a Mr. Badham had sworn out a warrant. So Shaw said, "I am not going." He resisted the arrest and claimed at trial that the arrest was not valid at the time of arrest. The officer had no actual possession of the warrant, and the state Supreme Court held that the warrant was in fact in the officer's possession. Right? The authority agrees. It says the authorities agree that in the case of misdemeanor not committed in his presence and for which he cannot lawfully arrest without a warrant, the officer should have the warrant in his actual possession at the time of making the arrest. It was not necessary that he should have the warrant in his hand or in his pocket at the time of making the arrest. The actual possession of it does not mean that. The rule is satisfied if the officer has such possession of the warrant that he can produce it with reasonable promptness on demand. So even though it was in his car 150 yards, then again, it needed to be still, he can produce it. And if it's asked, you do have to show, right? Because that is part of the procedure. So the question of what constitutes possession of warrant has often been debated, but it's obvious that it must be so close at hand to show it upon request. So if it's requested, it must be shown. Thus, it need not to be said that the warrant must in all cases be directly in the hand of the arresting officer. This would be too narrow and technical view of the law and one not based on substantial grounds. One reason for actual possession is to show that the authority for the arrest, another is to display of or read the warrant, and since this is to be done promptly, the possession must exist. Thus, the warrant must be in possession but not necessarily in hand, as the Federal Circuit Court Appeal stated. The officer who seeks to arrest by virtue of a warrant must have the warrant in possession at the time of the arrest. We do not need to define exactly what is meant by in his possession. Of course, it does not necessarily mean that the warrant shall be actually in his hand. But again, close enough for them to you request they have to actually show. So where a warrant was directed to all police officers and exhibited to 2 officers, but was kept in the police station, the warrant was not sufficiently in possession of the 2 officers to sustain the arrest by them. So in the rather famous and landmark case, Crosswhite versus Barnes, man, this is a serious case. A warrant for the arrest of Mrs. Barnes was issued by justice for a misdemeanor and placed in the hands of W.T. Crosswhite, chief of police. Crosswhite, along with a police sergeant, set out to execute the warrant, but left the warrant of arrest in his desk at the courthouse. When the officers first saw Mrs. Barnes, she was driving down State Street in her automobile. Police turned their car in front of Mrs. Barnes' car to stop her. One of the officers opened her car door, took hold of her by arms, and said, "Get into my car." She refused and told the police she would not go anywhere without her husband. The policeman said, "We want you, not your husband." She asked the officers to show her a warrant. Mr. Crosswhite said he did not have to do so and said that you are going to the courthouse. The argument continued, ending in Mrs. Barnes being forcibly taken to the courthouse, and Mrs. Barnes brought an action against Crosswhite and the other policemen for illegal arrest and assault and battery. The police were found guilty, and on appeal, the Supreme Court of Appeal of Virginia affirmed the conviction and is very authoritative in decision stated. So one of the things I've learned is reading this even more and more, guys, you have to make your claim, right? They're going to have their situation, but it is up to you to actually go out of the individual who actually harmed you. Because as they said, this is a tort claim. So it's literally up to you to make this claim yourself, right? You have to do this yourself. So the textbooks generally state, and many cases hold, that it is necessary not only that a warrant of arrest should have been issued, but the officer making the arrest shall have it with him and show it on request. In Bill's crime, it said that an officer arresting on a warrant must have the warrant with him and must show it on request. It is said to justify an arrest under a warrant, the officer must have it in possession, and if though delivered to him, he leaves it at his officer's station house, it would not protect him. So, speaking of misdemeanors not committed in the presence of the officer, it is said that the officer should have the warrant in actual possession in order to justify the arrest. And if he does not have it, although it has been duly issued, an officer making an arrest may not be protected by it. Like, man, how many times does this happen? How many times have y'all watched this happen? Just watching on, on your Facebook and everything like that, watching all the times that they go and they cause harm to these people every single day. Like, we see this every single day. Do we not? Do we not see this every day? Like, we see it all the time. So it said the court also referred to and relied upon a previous case in Virginia, the case of Musco versus Commonwealth, in which a policeman undertook to arrest Musco for a past misdemeanor. And he did it without a warrant. And guess what? Musco shot and killed him. Dang, Musco. Don't do what Musco did, family. You won't live to make the lawsuit. Do not do what Musco did. And if your family, they won't know what to do either. So, yeah, just don't. Okay? He was convicted of murder, and in the appeal, the court reversed the conviction. Jesus. The court reversed the conviction, y'all. Like, think about that. The court reversed the conviction, stating, indeed, not only must there be a warrant in the class of cases last mentioned, misdemeanors, but to justify the arrest, the officer must have the warrant with him at the time. Since a warrant must be in one's possession to arrest, a sheriff has no authority to send a deputy to one place to make an arrest without a warrant, while he goes to another for the same purpose with the warrant. Nor can he send his deputy into one town while he gives pursuit in another. Under the ancient practice of hue and cry, before warrants were issued, this might be done in the pursuit of felons, but no hue and cry could be raised for misdemeanor. We think it clear that in cases of misdemeanors, the sheriff must be present either in sight or hearing, directing the arrest to justify a person's not armed without the warrant to make the arrest. So in Georgia case, a warrant was issued for the arrest of Shaw, charging him with a misdemeanor. A warrant was directed to any sheriff, deputy, coroner. A coroner? For real? Damn. Or constable of the state. Now that's interesting. That means the coroner got a lot of power. I'm going to have to read about the coroner, which I've heard before. But reading and seeing that, that's powerful, right? Or a constable of the state. When the constable tried to arrest Shaw at his home, a friend named Adams interposed and asked the constable if he had a warrant for Shaw. The officer replied that he had it in his home, but not with him. Adams thus prevented the arrest of Shaw and liberated him from the custody of the constable. Adams was charged with interfering with the arrest. Supreme Court of Georgia held that Adams was not guilty of any offense since Shaw was not legally in the custody of the officer by virtue of lawful arrest. The constable had no authority to arrest except under the warrant, which he did not have in his possession. The court held whenever a warrant has been issued to arrest a person charged with an offense in respect of which he cannot be apprehended without a warrant, the police officer must have the warrant in his possession at the time when he executed. If he has not, the arrest will be illegal. Yo, I think that's something, man. You know what I'm saying? Like that's really something. That's something right there. And again, the coroner. It's just been yeah, they can make an arrest. That's interesting, right? That's my first time kind of reading something like that, but and I've read this many times, so that lets you know every time you read something, you'll get a little bit more out of it, right? So the warrant to be shown up on arrest, coupled with the requirements to have the warrant in possession when making an arrest, it is a requirement to show or display the warrant to the arrested person. Where an arrest is claimed to be made under the authority of a warrant, it is the duty of the one making the arrest to show the warrant and read it to the one being arrested, especially when he requires to see it or demands to know when the nature and cause of the arrest he needs to submit if this is not done. So again, the key word is requested. Okay? Requested. We are reading a treatise on false imprisonment by Charles Wiseman. Okay? But again, you have to request it. So, in the case of Smith versus State, the Supreme Court of Mississippi not only said that the warrant must be in the actual possession of the officer, but he must show it to the accused if requested to do so. Okay, in State versus Shaw Supper, the court said that the reason that a warrant is to be in the actual possession of the arresting officer is that if demanded, he must produce the warrant and read it to the accused, that he may know by what authority and for what cause he is deprived of his liberty. Right? And in Crawford versus Barnes, Supper, it was stated that the arresting officer must have a warrant with him and must show it on request. It is cited on numbers of authorities in support of it, such as the followings as well, right? So all of these are telling you that they have to have them. Got to have the warrant on them, right? So make sure the warrant is present. So invalid and unlawful warrants. Watch this. A warrant must have certain requisites in order to render it valid and available as defense. Many unlawful arrests have been made due to warrant failing to meet such requisite. Whenever a warrant is invalid on its face or where it is only a summons, the officer arresting the defendants will be liable as damages. So a prima facie invalid warrant will be regarded as no warrant, and the officer making an arrest by void or invalid warrant is not protected by it. So process that is void on its face is no protection to the officer who executes it. If a warrant, order, or writ of possession shows lack of jurisdiction of the court, the officer is not protected in serving it. In fact, in so doing, he becomes a trespasser. So again, it has to be stated for you a certain type of way. All right? It has to be a certain type of way. Everything must be by the books, guys. Okay? Now, I know I said that was the last one, but this needs to be covered too, because this goes with it. So bringing an arrested person before a magistrate. This is another part you need to know. So let's say you are arrested, right? This is what must happen. So it is the fundamental rule of procedure well granted in the common law that where an arrest is made, the alleged offender is to be taken before a magistrate to be dealt with according to law. This is not only to be done, but done without delay. Again, without delay or without unnecessary delay. Otherwise, the arresting party is liable for a false imprisonment. False imprisonment. Yes, if you are pulled over with a warrant requested on the scene right then and there. And then if they arrest you, they have to take you to the magistrate without delay. They cannot take you to jail, fingerprint, and do all of that crap because I'm finna show you why. So a constable may without warrant arrest anyone for breach of the peace committed in his view and carry him before a justice of the peace. The officer must bring a person he has arrested directly to a magistrate. Otherwise, it is a what? It's a breach of duty. It is the duty of an officer or other person making an arrest to take the prisoner before a magistrate without reasonable diligence with reasonable diligence and without unnecessary delay. And the rule is well settled that whether the arrest is made with or without a warrant. So with or without, doesn't matter. You supposed to go directly to the magistrate. An action for a false imprisonment may be predicated upon a reasonable delay in taking the person arrested before a magistrate, regardless of the lawfulness of the arrest in the first instance. So, thus, even if the arrest was lawful, a failure to take the person arrested to a magistrate will be regarded as unlawful imprisonment. Man, listen. Listen, as the Supreme Court of Minnesota held, even though an arrest be lawful, a detention of the prisoner for an unreasonable time without taking him before a committing magistrate will constitute false imprisonment. In an exhaustive decision on the common law rule of the process and procedure for arrest, the Supreme Court of Mississippi, in the case of Oregon versus State, said by the common law of England, an arrest without warrant for a felony can be made only for the purpose of bringing the offender before the civil magistrate. Why? Because it needs to be determined if they have enough evidence to charge you. That's the purpose. Do they have enough evidence to charge you? That's the whole purpose of going to the magistrate in the first place, because then that is where the warrant is given to keep you for an arrest and you're fully charged, right? Okay? So now, here's the thing. The procedure is the due process of law to be followed in depriving one of his liberty. Thus, a failure or even a delay in following this process is an unlawful restraint or deprivation of liberty, and thus a type of false imprisonment. The arresting officer has no authority to take a person to jail and detain him there. His duty is to take the one arrested without delay to a court or magistrate, as said by the Supreme Court of Kansas. So the law contemplates that an arrest either by an officer or private person with or without a warrant is a step in a public prosecution and must be made with a view of taking the person before a magistrate or judicial tribunal for examination or trial. And an officer even subjects himself liability if there is an unreasonable delay after an arrest if presenting the person for examination or trial. The only person that can justify having an arrested person in jail or detained by an arresting officer is as necessary step in bringing him before a magistrate, as so stated by the Supreme Court of Rhode Island. When the officer makes an arrest without a warrant, it is his duty to take the person arrested without unnecessary delay before a magistrate or other proper judicial officer having jurisdiction, in order that he may be examined and held or dealt with as the case requires. But to detain the person arrested in custody for any purposes other than that of taking him before a magistrate is illegal. So listen, thus detainment in jail for purposes of booking or fingerprinting or investigating the alleged crime or interrogation of the prisoner is illegal. Man. Drop some ones, man. This is a lot. Cause I can think about how many times like people go through this. I've even been through some shit like this in my life. And I'm sure some of you have too that's listening right now. Some of you probably went through it over the past couple holidays here. This happens. See, this goes back to everything we talking about, false imprisonment. Did you not know that roadblocks is a form of false imprisonment? You're being detained and they have to find you in illegal acts first. Where did you find me doing the misdemeanor? What am I doing? Like, they can't even do roadblocks, bro. All of that shit will get thrown out. Literally. And if they throw it out, then you can consider it malicious, or because it can be malicious based upon them wanting for a probable cause. You know what I'm saying? So think about it. In cases involving the commission of the most severe crimes as felonies, the one arresting is still required without unnecessary delay to bring the prisoner to the nearest magistrate or court as a matter of fundamental law. From the earliest dawn of common law, a constable could arrest without warrant when he had a reasonable grounds to suspect that a felony had been committed, and he was authorized to detain the suspected party such a reasonable length of time as would enable him to carry the accused before a magistrate. And that is still the law of the land. The court went on to state that the officer making the arrest is liable for the false imprisonment if he arrests with the intent of only detaining, or if his unreasonable delay causes a detainment. It cannot be questioned that when a person is arrested, either with or without a warrant, it becomes the duty of the officer or individual making the arrest to convey the prisoner in reasonable time and without unnecessary delay before a magistrate, to be dealt with as the exigency of the case may be required. So, the power to make the arrest does not include the power to unduly detain in custody, but on the contrary is coupled with a correlative duty incumbent on the officer to take the accused before a magistrate as soon as he reasonably can. If the officer failed to do this and unreasonably detains the accused in custody, he will be guilty of a false imprisonment. So he's guilty. And it has to be the officer who arrests you. Thus, when the person arrested is taken to jail or sheriff's office and detained there with no warrant issued before or after the arrest, it is false imprisonment. The one arresting has a duty to immediately seek a magistrate, and that failure to do so makes false imprisonment. As a matter of law, it is held by all authorities. So in case involving indictment for assault and false imprisonment, the Supreme of North Carolina held that in the process of lawful arrest, the one arrested is to be taken immediately to a judge. The question occurs, what is the officer to do with the offender when he shall have been arrested without a warrant? All the authorities agree that he should be carried as soon as conveniently may be before some justice of peace. Interesting, right? They got to bring you. They have to bring you before a justice of peace. Man, ain't this something, guys? So how do you guys feel about this tonight? Just learning this tonight, right? This is amazing because I really don't see how anybody, you see what I'm saying, understand. I really don't think I understand like what we be missing out on when it comes to not knowing our rights. You know what I'm saying? And that's the whole entire thing about this, right? We have to see it from that perspective. And we need to see it now from that perspective, right? And if we don't see it, and that's where the harm becomes in that. Right? That's where the harm comes in. I want you guys to know that. Right? That's where the harm comes in. We don't need that harm. Right, so drop some ones, family. Drop some ones. Let me know you're still with us. Drop some ones, yo. Alrighty, guys. Man, I definitely appreciate you guys for locking in with us tonight, man. Do not forget about the upcoming class tomorrow. In God We Trust. Academy Work Session Season 5, Monday, 11 a.m. Central Time. Make sure that you do get signed up for that. We also got the private administration class December the 7th, the conference here in Huntsville, Alabama, December the 7th. So you guys are welcome to that, 10 a.m. to 4 p.m. In person 200, 250. The live stream is actually 200. And there's going to be a lot of powerful, impactful information that's going to be placed in that. A lot about what we talked about today, private court settlement. I'm going to show you how to approach these things privately and handle some of these things without even having to go to court as well, whether it's credit, whether it's dealing with something lawfully like we're talking about today, you know, arrest. We're going to talk about it all. So just make sure that you be there, man. It's going to be great. You will be able to receive the templates and playback of the recording as well. And it's always going to be fun for those of you that are present with us, because you know how we get down after we eat good, we fellowship good. You know, some stick around a little longer, an extra day or so. So we all kind of link up the next day. Just a loving fellowship type of place, right? So be ready for that. Also, don't forget about November the 29th. It say 2025, but it's really 2024. This year, we're having a White Friday sale. Everything gets half off except the upcoming class, which is December 7th. So you guys will be able to go on there and get everything half off. So save up to that time, family. And we always appreciate you guys for joining us. Continue to share, log in with us on all social media websites at this point. We're pretty much on. Well, we're not on X yet, but we will be on X soon. I just learned what that means, because I'm like, yeah, you do this on X. I was like, bro, what's that? That was like Twitter. I was like, oh, okay. Yeah, I'm a little lost on that. But anyway. So we're on Twitch, In God We Trust Academy. We're also on YouTube, In God We Trust Academy. Follow us on Facebook, In God We Trust Academy, as well as following me, Eric Ingram Bay, as well, right? On Facebook. I got a blue check beside my name. Those of you that are also, we are on TikTok, MNRP 619 2020. Again, MNRP 619 2020, or you can just look up Turban Swag. It'll pop up there as well. So we're on a couple of different platforms sharing this thing with you guys. Make sure you log in with us. We will be on things like iHeartRadio and stuff like that pretty soon as well too. So we're going to be everywhere, right? And again, just appreciate y'all. Appreciate the love. We're about to turn up one more time before we get up out of here. Make sure y'all share, man. Let me know how was class tonight, man. Talk to me. Y'all got any questions? Drop them. We'll answer some here in a minute, too. All right, anybody got any questions for us right now? Any questions? Any questions? See, I had a few earlier, so I'm going to allow y'all this time. What are you guys' questions? Let's talk about it. Help me with your questions. Maybe I can answer a few. Answer like 3 or 4. I think tonight's class was great. It was needed. I think you need to share this with your people. Can we file on 95A? I don't know what you mean by that. I think you might be talking about one of those GSA bonds or whatever, but we talking about suing. You don't need those bonds if you're suing. But, you know, if you're doing it for those cases and stuff, that's cool. Why would you have a claim against the United States right now? Anybody with some questions? How much you charge me to help me with a lawsuit? Bro, I don't got the time. I don't want to take your money like that. I do not have the time. not have the time, to be honest with you. I really don't. What I have the time to do is what I'm giving y'all. Other than that, I got so much going on. But all you gotta, it's just like, what is your lawsuit about anyway in the first place? If it's about what we talked about today, I mean, all you gotta do is express it. Go get the Constitution. Show where they are violating due process of law. That's always gonna take you to the U.S. Constitution, the Fourth Amendment. But if you can find it about due process of law in the state's constitution, it'll work even better for you. So that's basically it. Just like I read to you, the guy's reading his case about how he expressed his. So, I mean, it just depends on what you're going to do, Daniel. If you're going to make it about the federal constitution, then yeah, you got to go to federal court. If you're going to make it about the state constitution, then you might as well file in the state. Either way it goes, you still got a remedy. You just have to exercise it. And the federal usually wants you to exercise all remedies within the state before you come to the federal. That's what they prefer. I heard you read that the man was driving with no license. Does that also include suspended? It doesn't matter. None of that matters. The thing is you're not operating as for commercial, and you're not a licensee, and you don't need them. If you're not operating for any commercial purposes, there's no need for a license. License is only given to those who are practicing something in the commercial world in trade, based upon goods, services, you know what I'm saying, products, business is that relationship. Anybody else? Anybody else? Anybody else? Let me know. Let me know. Let me know. Let me know. We got you if you're ready. Anybody else? Legal ain't lawful. I know that's real. Never is. Alrighty then, I guess that's going to be it for the night. When drawing up these claims, do we use statutes and codes? I mean, if they violate them. But you don't have to. The only thing you got to do is use the Constitution. I'm sure I told you. Just express it. Like, learn to express the Constitution, because all statutory and codes has to be in harmony with those. If they are in conflict of interest, then the higher law win, which is always the Constitution. So that's a fact. All right. So we will be closing out, man. So we'll holler at you guys tomorrow, 11 a.m. Central Time. Make sure y'all log in with us. We will be live.
Where we came from. All of my homies on one accord now. We don't ask questions like what can we afford now. All of my homies important now. You break the code, you deport now. We play the game like a sport now. Endorsement straight from the hood now. Man, on my way, then we good now. Don't approach me unless you more now. She approaching, asking for more now. Pick your head up, don't hit your head down. The struggle will sun up the sign down. I found my peace and we here now. Cold or honor up in here now. So lay down the law, keep it real now. They lower your oil, it's man down. I got a few killers that shoot around. You know we keep peace, ain't no backing down. He said for my family, now he asking for treaties. Just watch out them niggas who acting so greedy. Them be the people who heart is so evil. Swear I couldn't do it with none of my people. Fuck with mail, this trigger I'm squeezing. Alertion the pussy ass nigga I'm sneezing. Look how we spinning. Look how we spinning. Look how we driving. Look what beside me. Look what I'm smoking. Look how we winning. Look how we spinning. Look how we spinning. Look how we driving. Look what beside me. Look how we smoking. Look how we winning. Look how we spinning. Look how we spinning. Look how we driving.